जैसा चलो ठीक है, शुरू में तो इंटरेस्टिंग है.
Okay, we can.
This is so today we will be discussing on ये थोड़ा हम लोगों ने जो issue लिया, this topic we have selected because in last 2-3 months we have faced some very peculiar kind of situation while handling certain assignments, and we realized a lot of deals are not getting done due to some very frivolous matters, frivolous issues on some very small points. I'll give examples also as we go ahead in this to understand that probably we are missing out on something very big for something very small, very ordinary, which is probably not effective also. So the idea is just to inform everybody that we should look at the larger picture instead of getting into too much of litigation or too much of legality and in the process losing out on the business good. That's the idea. Now when I'm talking about negotiation, there is a disclaimer. This negotiation is not about a fees, it's a negotiation about how to negotiate between the landowner and developer, or say any real estate deal for that matter, any kind of transactions. So this presentation is broken up into two parts today. One is negotiation and one is how to draft a document. What are the important things which we have to ensure, and what are the points which we should ignore, I mean which are not really very relevant from the business point of view, whole deal point of view. So first of all, the whole purpose of negotiation is to reach consensus ad idem, which means to arrive at a consensus between the parties. We have covered it into these processes: elements, process, influencing factors, what are the good practices, what are do's and don'ts. Coming to elements, first of all, before we start at all, we get into negotiation. This is something which is very important to understand, that the parties who are involved in negotiation, what are the relationship between them. There could be partner disputes, so the parties know each other well, they know the intricacies of each other well. That is something to be considered. But where they are, आइए सर, सब आपको ही वेट कर रहे थे. आपकी चेयर उधर रखी हुई है, उधर बैठना चाहिए.
ठीक है.
So if you know the party well, that really helps. If you've gone through a broker, obviously things are a little different. You really don't know the other party, how aggressive, how soft, what are their needs, all those things. So this becomes a difficult situation. Whether there is a communication between the two parties directly or it's a via something. So direct communication, indirect communication, and the style they adopt. Style they adopt, as I said, whether they are very aggressive, whether they are okay. So this behavior part we have to first take into mind and be very careful about. Process, what is the context of negotiation? I mean, what exactly are we negotiating? Whether we are negotiating as a developer trying to enter into a development agreement, or we are negotiating a buyout of a partner. So all these things have, each transaction will have a different way of negotiation and a different context. Sequence and stages, we should be very clear of sequence and stages. How the parties negotiate, again, whom are they putting in front for negotiation. Normally we have seen that sometimes if there is a dispute resolution kind of a situation, then the parties, they themselves don't come forward. They will send some of their person to come and negotiate, and then he will have a standard line, okay, I'll go back, talk to sir whether this is acceptable or not. I think the negotiation process should not be started on these kind of terms. It should be the person with authority to take decisions should only be sitting for negotiations. Tactics used, lot of tactics are used. Emotional, first of all, lot of emotions are used for this, and that is something which we should be totally be very careful of and avoid emotional part of it. People will use emotions. Ignore the emotions, let them get emotional, let them try to make you emotional. Forget about that. Let's focus on what we want to achieve in a transaction. That is most important. It's the business part of it which is important, not the emotions part of it. Substance, agenda, issues and options. What is the agenda? What are the issues involved and what are the options we have? That should be very clearly etched out before we sit for negotiation. Now normally this is where everybody starts negotiating from. That's why the earlier two stages, these two things are very important. These two elements are very important to understand before we are going for negotiation. We should not straight away jump to the substance, because if we know that, a lot of things can change here. There are three stages: before, during and post. The entire focus is on during negotiation, but as I said earlier, the stage prior to that, before negotiation, is very important because it sets the tone for rest of the things. Now, before negotiation, what are the things which we must have? Try and collect as much data as possible. That data could be, not only I'm talking about the financials or the numbers or anything, data could be about knowing the person with whom you are trying to enter into negotiation. A lot of data is available on, just go to Google and you'll get to know. You'll get to know if it's a land deal you are trying to enter, say in Pune. You can probably search about that land, whether it's under litigation, whether there has been any news about that land or about the person who's the owner, whether there have been some criminal cases or X, Y, Z, everything is available on the internet. So if you have a preliminary knowledge about that, then you know, okay, the person with whom you are going to meet or negotiate or talk to is of this particular background. So that helps. Enhance your partners. Partners means the best alternative to a negotiated agreement. It means, basically in short form, it means, simple words, it means having your choices or options open as to what, if not this, then what. What is the best alternative to what you want, that you should, if you have worked on that, then you can create more options if you have thought of it before going for negotiation. This is to the professionals involved. If they are interacting with the clients, if they are going with the clients to those meetings, then they should discuss with clients to understand what their specific need is. Sometimes we go, and so many times Bansali Saab is here, it takes me to Pune or somewhere, and I always discuss with them in the car, okay, what exactly do you want, what exactly you don't want. Let's be very clear, because when emotions run high, you want everything in your side, even if it's not justified. So sometimes you have to sit down and get the emotions out of it and get to the absolute business brass tacks that, okay, this is what we want. Know the counterparty and their counsels. Their counsels very important, because we have experienced all kinds of counsels during our negotiations. In a Panvel deal, we found a very nice opposite counsel. He was so nice that every suggestion we made, he used to gladly accept it with minor modifications, and all was very positive. At times we have found one guy coming from Pune, he had come with the ultimate intention that ye deal nahi honi chahiye. So everything we said, no, it's not acceptable, totally unjustified. Fortunately, they changed the council. I think Bansali, in your case also, they changed that council, that landowners. So there's no point being too aggressive or to show to your client that no, so much you are thinking about it, because the deal won't happen. So the client is going to chuck you out. So anyway, so it doesn't happen. Assess the need of the other party. I think I don't need to tell this, because you all are smart here. You all do this much before, I think this is the first point when while starting negotiation, कि दूसरे की क्या जरूरत है. Then this is very important again. Focus on critical issues. Most of the times we don't. We get into say 20 points. Okay, these are these things we want. But out of that, what are critical, what are not, it should be clearly segregated. What we do normally is, in our files, we put it in 3 different colors: red, green, and blue. And we know, okay, the red, we cannot compromise on that. We will search for options and all. But these reds we want. Blue and green we keep for negotiations, options. Okay, if we give a green point, we want a blue point. Those kind of things we play within our mind. We have in our file, but when we go in the meetings, it's in our mind, that pictorial graph, and we work accordingly on that direction. So have your critical issues ready. That is very important. Mode of communication, again, whether it's going to be through emails, phone calls, conference calls, personal meetings. If personal meetings, who all will be attending it? Who all will be attending is a very important aspect of the matter. Lot of times, we feel that brokers should not be a part of certain negotiations. Initially, that does not happen. Initially, obviously, you have to go through the brokers, because they are the people who will break the ice and all. But a stage comes when certain critical issues come. It's better to have a one-to-one talk, because a lot of issues get sorted out when there is a one-to-one talk, in absence of lawyers and in absence of brokers. Lawyers also not needed a lot of times, because they tend to get too legal about the matter without understanding the business needs of both the parties. So, if possible, avoid them also. Studying the business environment, you don't know what policies are going to come. Probably you're looking at, okay, something positive is going to come, so this deal could be good for me. That policy may or may not come, or probably you have some inside information about certain things. So that helps in negotiation. Okay, how does that happen? Analyze deal breakers. This is again very important to understand what is it which will be a deal breaker from the opposite party's end. What he will surely not agree to. That is very, very important to write down, probably be very clear on key, okay, this is the point, he will not go below that. If he goes, okay, it's good, I mean, you have struck gold. But if he doesn't go below that, then you should have your options ready. So deal breakers you must identify. Same with in your own case also, you should be very clear that okay, these are the points which are going to be deal breakers. Below this I will not go. But these deal breakers have to be very, very limited in number, because ultimate objective is to get the business, to do the business. Legal issues can never become deal breakers. Never ever get in the mindset that उसने ये line नहीं लिखी तो मैं deal नहीं करूँगा. That is a very wrong way of doing it, because वो line लिखी नहीं लिखी उसका कोर्ट क्या इंटरप्रेट करता है, वो सब ifs and buts है. उस पे business नहीं होता. Business happens on numbers. Okay, you can say okay, इतना deposit है, इस deposit से ज़्यादा मैं नहीं दे सकता. That's okay. Those can be deal breakers, but never any legal issue. I mean, we can't emphasize more on this, that please don't think the other party is fool. So many times we get to make agreements which we know these are horrible agreements, but on client's insistence we write those clauses and we know it's going to come back deleted. There's no point wasting time on it. And what happens is, the moment you send a document which you think that okay, other party is going to accept it, it creates a very wrong image in the other party. He gets very uncomfortable. He starts feeling ki, I don't know whether this is the right guy to do the business with. What kind of lawyer is he having? Those kind of things start coming in. Try and send as balanced document as possible in the beginning. Obviously, there will be clauses which will change from that also. But totally one-sided document, avoid it in the front end, because it's really going to break the deal. Nothing will move. Identify and prioritize the objectives as we discussed. This is the kind of chart which we prepare. This is just a format which we normally do within our thing. We never share with the clients, obviously, because this is our internal thing. I'm just giving you the format. We identify, okay, these are the commercial issues. We break the issues into commercial, legal, and there are certain issues which are both commercial as well as legal. It's a mix. Can't distinguish. So we break it up. We create what are the best options and at what level it will be a deal breaker. Most of the times the commercial figures keep changing. Our client also keeps changing them. Okay, ठीक है, अभी ये नहीं तो ये, चलो ठीक है, deposit बढ़ा दिया, लेकिन percentage कम कर दिया. So that interplay, that commercial thing is quite flexible. That is okay. Legal side, only we know what is important. So we know, okay, if he's handing over the possession, अपना काम हो गया. बाकी वो चार चीजें लिखता है उसमें, he will have the right to enter, ये वो लिख ले, क्या फर्क पड़ता है, possession हमें आज दे दिया. So we know, okay, this legal clause will be extremely important. Rest are all okay. वो नहीं भी किया, उसके lawyer ने 10 change करके भेजा, accepted. Okay, fine, ठीक है, let him be happy. Ultimately, he has given you the main thing. So we know, okay, these legal issues, they are not negotiable. Rest all are. Even in that not negotiable, I will not say it's totally not negotiable. What I mean is that we want to get it covered in some manner or the other. We can find alternatives to the wording or things like that, but we want to retain it. We will not delete it totally. That is what we mean by this. So the best, when we say the bargaining zone in our mind is that there is the best deal option and there is a fair deal. The deal will always happen in between that. You will never get the best deal. Probably you will never want a fair deal, you will want more than that. So the deal will always happen somewhere in between. If you are getting something more than a fair deal, I think it's okay. It's a deal to deal. So this is, most of the times, we have achieved the fair deal. We have moved much ahead from the fair deal towards best deal, but it's still not best deal, so we don't want to do the deal. So that is where we go wrong. So let's always have this thing in the mind that okay, what is the best deal, what is the fair deal. Lot of times, with the time the situations change, especially in real estate. Each project takes a 3 to 4 year minimum period. So in that 3 to 4 years, lot of situations change. So all that what we are negotiating today will probably have no meaning 6 months down the line. So a lot of things get diluted and things like that. But this is what we always believe in. And during negotiation, the process initiate, critical issues first, because a lot of clients have this habit of saying कि ठीक है ये critical issues है, ये बाद में देखते हैं, पहले ये minor issues discuss कर लेते हैं. It's a time waste, because होता क्या है, you discuss all the regular stuff and then you come to the critical issues, वो deal breaker हो जाते हैं. So all that much water दो महीना उसमें लगाया, सब वो सब waste है. Instead, take the critical issues first. Once you have cracked the critical issues, once there is a consensus on critical issues, rest of the issues which are not critical will flow very fast. Then it's a matter of process. And there we have seen the clients getting very impatient, saying यार critical issues हो गए, अभी इनमें क्यों टाइम लग रहा है, ये फटाफट खत्म करो, ये करो वो करो, register करो document. So critical issues should be taken up first. Listen to the other party, have positive approach, give more time to important points. Again, those are the points which we need to discuss, thrash out, negotiate more, rather than simple points like कितने copies बनेंगी agreement की, एक copy तू रखेगा, एक मैं रखूंगा, original किसके पास रहेंगे, all those kind of things doesn't matter. It really doesn't matter. Once you have registered a document, it's a public document. किसके पास copy रहेगी original, it will have no implication at all. Think of alternatives, as many options as you can create, because you want that deal should happen. Address all relevant terms, means commercial terms. Try and address, don't brush anything कि ये बाद में देखेंगे 6 महीने बाद क्या होता है, अभी उसने नहीं रेस किया तो छोड़ देते हैं. Avoid argument. Very difficult, very difficult, but very important. Because lot of times your deal may not happen at that point of time, but if you have kept the door open by your behavior, then that deal comes back to you in some other modified form. Or so there is always that option. Avoid deal breakers. Bargain, compromise, use parking lot. By use parking lot, I mean that say you have reached a 90% consensus. There are 10% of issues which you are not able to decide in that very meeting. So you will always say, okay, we'll put it in the parking lot. This is a commercial term. Parking डाल देते हैं. एक हफ्ते में वापस इस पे अप्रोच करते हैं. Let us see, we'll also think, you also think, and all those kind of things. So use parking lot. Don't say कि ये नहीं हुआ तो deal नहीं हुई, खत्म, चलो, okay, bye. Good. Think probably issues will, you'll get some options. And just 2-3 days back we had a very interesting incident. Ansari sir is here, so I share it. In one of the deals where he was getting a lot of money, and those guys were issuing a part of the total amount they were giving as PDC, post-dated checks. So in the receipt we wrote subject to realization, which is a very normal language. Those guys said no, we will not write subject to realization in the receipt. Entire document done, freeze हो गया. Receipt के last page पे last line subject to realization, वो बोले हम नहीं लिखेंगे, हम बोले नहीं लिखेंगे. Ansari sir got furious. He said नहीं करना deal, मेरे को नहीं करना, sign नहीं करूँगा, and all those things. I also said yes, subject to realization कैसे नहीं लिखेंगे? It's such an important part. You're giving a PDC, obviously it has to be subject to realization, right? That's what we all think. ठीक है. Then I said कि चलो let me research on this point. What does the subject to realization mean actually? I mean, what is the legal connotation of this? We are also stuck, they are also stuck. इतनी बड़ी डील नहीं हो रही है करोड़ों की. सिर्फ एक लाइन की वजह से पूरा 10 पेज का डॉक्यूमेंट फाइनल हो गया. एक इन वर्ड, लास्ट लाइन अटका हुआ है. I did a research on this and I found that subject to realization doesn't mean कि अगर check bounce हो गया तो you cannot have any remedy. Check bounce means check bounce. It has all the remedies. Subject to realization only means whether the date of giving the check will be treated as the date of payment or whether the encashment of check will be treated as date of payment. And it is important only in case where you are levying interest. So if the check is honored, then the date of payment is treated as the date of issuing you the check, the date on the check. But if the check is dishonored, then that subject to realization doesn't affect anything. Dishonor means dishonor. So irrespective of whether you've written subject to realization or not. So I discussed with him. I said, Ansari sir, इसका कोई implication नहीं. Coincidentally, probably they also studied the opposite party. They also came back and said, हम लिखने को तैयार हैं. So next day the document was signed. So what happens is, I mean, for such a small thing, your crores worth of deal is getting stuck for no reason whatsoever. Both the parties are stuck because both don't know the law. And once you research, then you realize it is of no significance at all. They have all the intention of honoring it, so they realize that इससे कोई फर्क नहीं पड़ता. So that is what happens in small things. So let's avoid those kind of mistakes. This I mean, we try to emphasize on our clients, let it be a win-win situation. Most of the clients say, ठीक है, win हमारा तो होना चाहिए, उसका है कि नहीं वो जाने. But then deals will not happen. I mean, with that kind of attitude. I mean, you can't have a Russian kind of a thing that okay, I win, you lose. That negotiation doesn't work. Nowadays, everybody is smart. Everybody has good lawyers. Not everybody can afford us, but still they have good lawyers, and still, you know, they all go back to their lawyers. They will discuss. They will thrash out. So we cannot expect that they will sign anything we give them. So that's not possible. Post negotiation, have a summary of negotiation. I've discussed in detail in next slide what this means. It's very, very important. Follow up on the this thing. Schedule next meeting means for execution purpose. What do you want to do? So schedule that next meeting. Factors influence process of negotiation. Time, very important. A lot of negotiations take place late evenings. Very, very risky. Half the people are not in their senses. What they are talking, what they are agreeing to. Next morning, all the clauses change. All the commercials they start reversing it. नहीं वो कल कुछ बोल दिया था, वो calculation बराबर नहीं था. आज ये है, तो यार कल का 4 घंटा waste. Place, obviously it's very important. We have seen these egos coming in. मैं उसके ऑफिस नहीं जाऊंगा, वो मेरे ऑफिस नहीं आएगा and all that. So हमारा boardroom ले लो यार, खत्म. Place is very important. Relationship and context, we discussed it earlier. If they are known parties, unknown parties, what kind of thing, style, whether they are aggressive negotiators, they are okay. You can be an aggressive negotiator but still polite in language. So communication skills, very, very important. How do you communicate? Cultural factors. This affect a lot of things. We tend to analyze this and we try to emphasize on our clients also that, say if you are entering into a deal with a landowner, the first question which comes in our mind is whether that landowner himself is a builder or whether he is just a pure farmer kind of a landowner who doesn't know much about building land, because it makes a hell lot of a difference in negotiations, in trying to understand them, in they trying to understand us. It makes a big difference. So if it's another landowner, another builder who's giving his land for development or things like that, then you are sure that this deal will either happen very fast or not happen very fast. There won't be much time wasted in this. So those cultural factors, what background they come from, really affect a lot. Language barriers, we face this because we don't know Marathi. So a lot of times when the developers come with the landowners, like yesterday it happened, the landowners came from Pune and Khushi was trying to address them. There was so much of a problem because they were not comfortable with Hindi or English. We don't know Marathi. So there were certain issues which are coming up, but fortunately we could sort it out. Personal relations. Again, if you know the parties well, then it makes a difference. If there's a personal relationship, then things are little different. Which legal system we work in, whether which law is applicable, whether transfer of property or which particular, that document is dependent upon which particular law. That is very important to determine because that will decide the clauses and things like that. The professional approach, gain trust. At times, we have this habit of trying to gain trust of the opposite party. We always tell them if there is a point in favor of a landowner, we may be representing the developer. Most of the 90% times we are representing the landowner, but the developer. But sometimes we find that there is a certain clause which will help the landowner more, and developer has nothing to lose. Maybe it's his taxation, service tax or whatever. Maybe something like that. We don't stop ourselves. We give that point to them because we feel that if we do that, then they tend to have a little more trust on us, and that really helps in drafting the document and all because they feel कि नहीं ठीक है इन्होंने लिखा है तो हमारे लिए सोच के लिखा हुआ. So it dilutes a lot of things. So we try to gain trust by helping them out in some point or the other because that helps in the entirety. Overall environment becomes little positive. Emphasize on common interests. It's related to gaining trust that okay, if something is of their interest then we do it. This is something very important. I mean, a lot of professionals do this mistake. It happens in meetings that okay, I mean the point is stuck. At some place negotiation is stuck. Now I have an idea that okay, this deadlock can be broken in some manner. Now I don't know whether to speak that or not because if I speak, maybe it's not in favor of my client for some other reason which I am not able to foresee. And if I don't speak, then probably this deal won't happen or it will be a breakup and we'll go back home and all that. So it's a very strange, very, very difficult situation at that point of time, whether to open my mouth or not to open my mouth. So this is a little difficult. So what we do is we try to discuss with the client in alone that okay, can we do it this way? If you feel this is okay, or in a modification of this, then you can suggest. So we let the client only make that suggestion instead of we making it, but we advise the client on that okay, this is the best way to do it. Deal issue one by one, not all at a time. One by one, take one, because if one is accepted, then other probably we can dilute it and things like that, since we have a priority of red, blue and green ready. So we take it up that way. Don't be aggressive. It serves nobody's purpose. Nothing happens. Don't be impatient. I think in real estate now everybody has learned this, not to be impatient, because there is no other choice. Don't make isolated concessions. This and the next point is correlated. Don't make concession unless conditional. What these points mean is that even if you have to concede something, say if we are conceding a blue point, as we call it, then we try to see that we should at least get something more on the red point, or maybe a green point we should earn. So it should not be just blue point, give up kar diya. Try and earn something out of it. Like we were discussing that day when they said that subject to realization nahi likhenge, and we discovered that it doesn't matter whether we write or not. So we discussed, me and Mansali sir. We said, okay, Mansali sir, you give up that point, but then you put in that okay, in case the check is dishonored, then we'll take so much of interest, so much of liquidated damages. So try to get something out of it, so that okay, chalo 25-30%, whatever you can get out of dishonor, we put that kind of a clause, so probably they'll agree. That didn't happen because they finally agreed to write those lines. But this is the kind of thing we should try and do if possible, and normally it works. So we do get something out of it, even if you have to make a concession. And don't focus on ghost risk. What we mean by ghost risk is that a lot of times we tend to get into a momentum where we keep thinking negative. ये हुआ तो क्या हुआ, ये होगा तो क्या होगा, ये क्या होगा, अरे जो चीज है नहीं, कभी हुआ नहीं, होने को तो कल गवर्नमेंट पॉलिसीज चेंज हो जाए, वो लैंड ही एनकम्बरेंस हो जाए या एक्विजिशन में चला जाए, तो क्या करोगे? बट वी टेंड टू थिंक सो मच दैट जो है उस पे डील नहीं होता, जो नहीं है उस पे नेगोशिएशंस पे डील ब्रेकर्स आ जाते हैं कि यू नो दोस्त वी कॉल एज घोस्ट रिस्क, जो है नहीं, दिखता नहीं, भूत है, लेकिन डर लगता है उससे. सो लेट्स नॉट फोकस ऑन दैट. This is basically for professionals. Meet client before negotiation process. Then अकेले में समझो before entry straight away entering into drafting of document. Understand their business need. Onerous obligations. What kind of obligations he is ready to take for the deal? That okay, these are the ones which I am ready to take. That this is my responsibility. Say as a developer, okay, I will construct at my own cost. There's that marketing, sales, any legal issues, all those things that I will take up. But others I will not. And then communicate with the counterpart. So now this is a topic which we covered because a lot of times this question comes up कि MOU हो गया तो अभी वो बाइंडिंग हो गया कि नहीं. सपोज वो MOU के अगर उसने मेरे साथ किया गया, किसी और के साथ भी डील कर सकता है, तो मेरे MOU का क्या होगा? You know, these are the things which are very critical. So let us understand exactly in what situation it is binding, in what situation it is not binding. There are a lot of Supreme Court judgments. We've done a very detailed study on this. And we are giving you these tips so that when you negotiate with any party, you know okay what are the 3 areas you will negotiate that ये हमें चाहिए MOU में, बाकी नहीं दिए तो चलेगा. So MOU is a preliminary agreement to record basic terms of transaction in advance. It is not a contract in itself. It's a preliminary agreement. So it's a framework for negotiation. What is it used for? For negotiating the basic terms. It's a general commitment to a project by both parties. The landowner says, okay, I will come. Developer says, I will come. The principal terms are recorded in that. It outlines the project to third parties. Say, on that basis on that MOU, as a developer, you want to get in a partner or something. So you have that MOU. Okay, these are my basic terms, and this is the project going to be AFSI, ASA. And it also initiates regulatory process. And mostly, और से 99% केसेस MOU के बाद आपको ड्यू डिलिजेंस एंड ऑल दोस का प्रोसेस स्टार्ट हो जाता है. सो दिस इज द होल पर्पस ऑफ हैविंग एन MOU. नाउ 3 क्वेश्चंस व्हिच अराइज. फर्स्ट क्वेश्चन इज व्हेन वी लुक एट it whether it is enforceable or not, these are the 3 questions we should ask ourselves while drafting the MOU. Was anything left for further agreement which was so essential to give effect to the agreement? Have we deferred something in the MOU? Have we said that okay, these are the things which we will decide later. Even if we have said that, if those terms which we have to decide in future are not critical to the entire agreement, then it can be a binding agreement. Yes. So even if you say that, a lot of people say, a lot of lawyers say, we have not concluded the transaction, this thing was to be decided. But if it's not critical, then it's not critical. Did the parties intend to be bound by the terms agreed upon? Now this emerges from the wordings used in the MOU. This is totally based on the language of MOU, especially the recital, the parties agreed, and also on the testatum. We covered as to what exactly it means. Subsequent slide I will explain that. So this is totally a lawyer's prerogative, what kind of words he used to give it as a binding or not. And whether consensus ad item is reached, that is whether there is a consent, a binding consent which has been arrived at. So these two things come from the language. Now if the answer to the first question is in negative, that is, was anything left for further agreement, and nothing was left for further agreement, and the second is in affirmative, that is the parties intended to be bound by the terms, then the MOU is binding, otherwise it is not. Second, if anything left for future was merely a matter of formality, as I said, it was something very minor, then also you can claim that MOU is binding even if there was something to be done. Say you said that due diligence we will do in future, that doesn't matter, that doesn't affect your contract as such. Karna hai, it's a process, it's a formality. Now if consensus is arrived at, it is binding, if not, then it is not binding. So we have to test the MOU or draft the MOU based on these things. It's not always binding, it is not that it is always not binding. So both things happen.
जो पहले वाला था सर, ऊपर सर नेगेटिव दे रहे हैं, नीचे सर पॉजिटिव दे रहे हैं सर अफर्मेटिव। हमने नीचे भी अफर्मेटिव में लिखा है, लेकिन ऊपर जो है ऐसा हो जा रहा है कि बात अभी कुछ होना था। ये दोनों कंडीशंस हैं, एक साथ होना मैंडेटरी या आइदर और।
See, इसमें क्या, there are different kind of judgments. What they say is basically that if you say that anything is left for further agreement, if say there was something left for further agreement, but and the parties had agreed to be bound, and that which was left to be done further in future is not material or just a formality, then it will be binding. So in that case, even if the first question is in positive, that there was something, still it will be binding. So you can't say that okay, just that one of this is fulfilling, so it is binding or not. It's an interplay.
Normally होता क्या है, जैसे क्लाइंट आता है बोलता है कि नहीं हमारे को बाइंडिंग MOU बनाना, तो हम जो एक स्टैंडर्ड लाइन लेते हैं कि दिस एग्रीमेंट इज बाइंडिंग ऑन द पार्टीज एंड सो ऑन। लेकिन अगर फर्स्ट कंडीशन फुलफिल नहीं हो रही है तो उसकी बाइंडिंग फोर्स इफेक्ट हो सकती है कि
बिल्कुल, वो तो फिर देन बिकम्स अ कंडीशनल एग्रीमेंट, एंड कंडीशनल एग्रीमेंट अगर कंडीशन फुलफिल नहीं हुआ देन इट फेल्स।
ऐसा कोई नेसेसिटी नहीं कि सिर्फ सेकंड लिख दिया है तो वो बाइंडिंग हो जाएगा।
नो नहीं वो नहीं, ये बहुत
गलत प्रैक्टिस है कि सेकंड लाइन तो आती है।
हाँ,
फर्स्ट वाला
we use different words like it's a definitive agreement, या जब हम टेस्टेटम में वो लिख देते हैं कि now the parties in agree and confirm and this and that, so that becomes a contract that okay they are bound by it
की डील में सर MOU पे स्टार्टिंग में ये पैराग्राफ लिखा था कि दिस एग्रीमेंट इज बाइंडिंग एनफोर्सेबल।
हाँ, करेक्ट।
तो सिर्फ वो लिखने से भी सर आपका पर्पस है।
Say your agreement MOU is dependent upon some government approval, that approval is rejected, what will you do with that MOU? Right, because your basic condition of entry into MOU is that the landowner will get this approval. If he fails to get it, you can't do anything with, उसको binding करेगा कौन?
तो सिंपली ये लिखने से पर्पस
कुछ नहीं होगा। Substance, that condition has to be fulfilled if there is any. But if those conditions are something very minor which is otherwise not affecting the entire deal, then it will not. Now we come to the second part of it, drafting of contract. This is a little technical, but we'll try to put it as simply as possible so that while negotiating you will understand, try to implement it. So what is a contract? Contract is a voluntary arrangement. These are the phrases which are very important emerging from Contract Act, so we have to know this. Voluntary arrangement, it can't be forced. Between two or more parties, you can't have a contract with yourself, so at least two parties are required. Which is enforceable at law. An agreement which is not enforceable at law is not a contract. You can't say that okay to the contract. So it has to be enforceable at law by the courts or anything, and it's a binding legal agreement. Like MOU is not a contract if it is not binding. If it's a binding MOU, then it is a contract. So these terms are all very important in a contract. It's not a piece of paper signing between two parties, but protects one's business entity with its rights and remedies. It creates responsibilities, conditions, manners, time limit, monetary issues, so that every corner of agreement is properly sealed, failing which it may result in unforeseen losses. The stages are, there is an engagement phase where you try and understand what exactly, before draft, these are the stages of drafting of a contract, that you try and understand as to exactly what the deal is. So that is, you get engaged to the parties and the matter to understand that. Then you analyze the data. You collect the data and information, you analyze that. Based on these things, you draft the document. That's a drafting phase. Then execution. Execution is registering, notarizing, whatever. You require board resolutions, you require parties to be present personally. So execution phase is very, very important. A lot of documents fail at this stage. We have discussed subsequently why they fail. Then it doesn't end here. If it's a long-term contract, then it requires a normal contract administration, that everything is going as per the contract or not. ड्यू डिलीजेंस होना था, हो गया कि नहीं, पेपर्स जिसको एक पार्टी को कुछ अप्रूवल्स लेके आने थे वो लेके आए कि नहीं आए, इतने पीरियड में पेमेंट्स होने थे वो पेमेंट्स हुए कि नहीं. सो दैट सब्सिक्वेंट टू एग्जीक्यूशन आल्सो दैट एडमिनिस्ट्रेशन पार्ट इज वेरी वेरी इंपॉर्टेंट. Now these are the basic points which basic things which come in our document. I will not go into detail. I just say the name of the document. Although courts have held that name doesn't mean anything, but still it's an important thing. We should have correctly named the document. There is an ambiguity. We normally write articles of agreement. We don't give it a name because as a strategy part. So we say okay, you can try and whisper it the way you want later on. Date of document and place of execution. We have discussed the date aspect subsequently. Again, one of the most ignored part of a contract. Very, very important. Your entire contract depends upon date. There are multiple types of dates in a document. You have to be careful what date you are writing and what it means. Parties, there are recitals. Testatum, again we have discussed in subsequently what testatum means. Consideration. All estate clause means whether the entire land is going or a part of land is going. So whether it's an all estate. Exceptions and reservations, whether there are any reservations on the land and things like that. Addendum is again whether it's the entire property or part of the properties. Terms and conditions. Covenants means the obligations which each party will fulfill. Description of property, very important. We have discussed in detail. There are some very basic errors which everybody make. We have discussed why and how those things. There are some Supreme Court interesting Supreme Court judgments where the document has failed because the property was not properly described in the schedule of property. The entire document failed. It was a sale deed. Testimonium, how will you close that, and obviously the final part is the receipt. So obviously nature, date, place, purpose, parties, then you have a definition, that offer and acceptance by parties, obligation of both parties, conditions precedent and subsequent we have discussed in detail. This has a very big legal connotation in a document. Most of the people, they don't break the document between conditions precedent and conditions subsequent, or condition subsequent is also known as closings. They have different legal implications. We'll discuss that in detail. Indemnification, security interest, delivery, risk of loss, who considers consideration, force majeure, then default clause, termination, expiration, assignment, whether power of assignment is there or not. MAC means material adverse change. Nowadays it is very important to put this because say today service tax is 15%, suppose it becomes 30%, who will bear it? So material adverse change clause must be there. It should be negotiated well in advance. It's not applicable to real estate this thing, but sometimes it becomes important in case of say retiring partners and things like that, whether you will use the brand name, you will not use the brand. So this is important. Confidentiality, non-compete, penalties and liquidation damages. Waiver, I'll explain this. These are simple ones. Notice and dispute resolution means arbitration or and jurisdiction means which court has a jurisdiction, whether Bombay or Delhi or whatever, in case of different states and things like that. Now we'll start with what are the important issues which we feel are important and which should be. That there is a date clause. We say this agreement is dated so and so. Now what is the implication of that? Very serious implications, very serious. First is It is of great importance, and if any legal action is required to be taken in respect of a document, in some cases, the limitation period, say it says within 3 years, law says you have to act upon, it runs from the date of document. You can draft the document in a manner that the date of limitation doesn't run from the date of document, but it runs from a subsequent date. So this is a very intelligent play which you can do in case you know that okay, you want to extend the limitation period of that. It can be put in testimonium, but testimonium means towards the end of the document. But best way is to put it at the beginning of the document, which we all do now, that this document is executed and should be written in words, not figures. Very, very important. I think 80-90% of documents we see handwritten date होता है, 23/08 ऐसा करके लिखा है. That is, it should be written in this thing. This is not a legal requirement. This is a suggested by everybody. You pick up any legal book on drafting, they will say please put the date in words, not in figures. And if you look at any English draft, they always have on so and so day of Christian year so and so, and that is how they define it. That is because they have a lot of case laws built up on these dates. It's easily alterable if you have written it with hand and things like that. So avoid those kind of things. Then here I will just explain what the difference is between a date clause. One is the date of agreement, which we discussed. Then we have an effective date of that document. Okay, this document could have been made on 1st of April, but it is effective on say a particular event or a particular period, after a particular period, that it will be effective from so and so date. And the third is the closure date, that this transaction will be treated closed on so and so date. So say you enter into a document of development agreement and you say, okay, this development agreement is dated 1st of April. There you put in that this development agreement will be effective from the date when you get the possession of land. So from that date till you get the possession letter in your hand, that landowner is supposed to get the land vacated and all that and give you the possession. So he takes 2 months, 3 months or whatever. So that possession letter which you get is the date when that development agreement becomes effective. And closure date is when you've done your due diligence, when you've received the approvals and you start actual development. You enter and you start excavating and things like that. So these are the 3 different dates which you can define in your document. Each has different legal implications, both from the legal point of view as well as from the income tax point of view. From the income tax point of view, the tax liability on landowner will not arise on the date of agreement in this situation. He can have a registered development agreement, but there will be no tax liability on him. Can anybody say why? Can anybody tell why? Not you, Roshan. You have already done a 105 slide presentation on development agreement. Not you. Anybody else? Why his tax liability will not arise on date of agreement if there are these 3 different dates?
Because of that effective date.
Correct. Why? What will happen on effective date?
The document comes into force on the document comes into force on that day.
He has given the possession on that date, on effective date. Till between date of agreement and date of effective date, he has not given you the possession. So transfer हुआ ही नहीं. And that also takes into the legal point of view, that from the developer's point of view, he has no remedy if in between that deal gets cancelled. He cannot go to the court and say, I have a binding development agreement which is registered after payment of stamp duty, so this DA could not have been cancelled. The court will say this transaction is not yet concluded. This contract is not yet concluded. It will become effective only on a particular date. So all these dates have a very serious implication both. So that effective date is the conveyance, possession. When you actually get possession is the transfer. So I am not saying that possession is the effective date. You can choose to define whatever event as an effective date, or you can put an actual effective date, that say 1st of September it will be an effective date, based on your commercial terms how you negotiate. But keep in mind all these factors when negotiating. बिल्कुल डाल सकते हैं, और उस केस में लैंड ओनर का भला हो जाएगा, बट डेवलपर का क्या होगा?
लैंड ओनर की भले है, क्योंकि सर लैंड ओनर डेवलपर सीसी नहीं ला रहा है तो हमने क्यों बैकएंड को बना रहा है आगे और सीसी।
हाँ, वो तो there is a Bombay High Court judgment on that now, directly on that point, that a development agreement becomes effective only after the developer starts performing his part of obligation. Suppose he is entered into a development agreement today, and for next 2 years, 3 years, he doesn't get even the building permission, CC sanction, whatever. He is not able to get. He has no right. That can be terminated.
डेवलपमेंट एग्रीमेंट हमारा पता है जिसमें 4 साल से कुछ नहीं हुआ है, फिर दूसरा डेवलपर ढूंढते हैं, बोलते चलो इसको पार्टनर बना लो, तो क्या उस बीच में फिर लैंड ओनर टर्मिनेट
कर सकता है, कर सकता है, कर सकता है। हुआ है यहाँ सोसाइटीज में कितना हुआ, सोसाइटी चेंबूर एंड ऑल दो, सो मेनी प्लेसेस बॉम्बे हाई कोर्ट से शाहपुर जी पालन जी के केस में। So you can't have a document executed and say that this is my deal. No, the effective date has to be determined from the contract. So dates are very important. Best is to actually define it. If you can negotiate on that. If not, then for strategic reasons you want to leave it vague, you can leave it vague. But keep this in mind. Another issue which arises on in an agreement is that if there are multiple parties and they sign on different dates, which date will you say is the date of agreement? Say there are 7 partners. Some partners are living in, some are in Pune, some in Delhi, some in this. Now you keep sending the document, sign. They all sign on different dates at different places. Which is the date of agreement?
Last signed date.
There is no there are various judicial confusion on that. Which date? Why do you say last date? Why not the first date?
Because the agreement is not complete.
But there is a see. There are judgments which say you need not sign a document to make it effective. A document can be signed even by sending an email. If say I send you a draft for signing, and you send me a mail saying I have read this and please treat it as my acceptance, it's a binding contract. You need not have signed it. So signing of that is not important. So there are judgments of both sides. What I am trying to say is you have to be very careful on this. What the courts have advised is, in such a situation, each partner or each person who is signing must also put the date of his signature next to it, date and place of his signature. What will be the interpretation of that? That we leave it to the courts. But to have a proper effective document, let everybody sign. It should not so happen that you have put the date, different parties have signed on a different date, but they have not put their signature. Then that document will get challenged by the parties. They will say in the court, I was not even at that place when this document was signed, so this is not my signature. That document, and there are judgments to that effect. There are actual judgments to that effect where the courts have said, no, this document is forged because that party was not in Bombay when this document was signed. Although he signed it in Delhi, but he did not put the place and the date of signing. So these are the kind of things which can happen. So it should be done wherever they are signing, whichever place, whatever. A lot of these things now get covered because you get the document either registered or notarized. So these issues are more or less lost because of registration. But then again, registration relates back to the date of execution. There are judgments to that effect also. So again, it creates a complexity. But it's best to put the date and time properly.
We had executed one document at 6 different places.
Is it?
And all the documents we were advised to get them notarized at their specific
Yes, correct. That was only because of this reason. Yes.
We were advised when we had done it. We had ensured. They said that it is not required. We said no, we will not do it.
Yes, correct. Very, very necessary. Otherwise, somebody will challenge it and say कि मैं तो था ही नहीं उधर तो मेरा कैसे sign आया?
इसीलिए name and date नहीं, but in presence of a notary of that jurisdiction.
So there were 6 notaries basically.
6 notaries.
Yes. Correct.
12.5% लेंगे.
हाँ, 12.5. उसमें तो probably all these things will fall short. You will need something more also. That also you try to cover the thumb impression part of it. We discussed that also. This is the same. If several parties to a deed sign it on different dates, the question is which date should be entered as date of sale. The practice is to regard the last of such date. However, it is not universally correct. There are different judgments. Now again, this is a common question which always we ask, that what is the difference between a deed and an agreement? We use it interchangeably, very freely. But assignee means very clear. Law doesn't recognize deed and agreement as only one thing. There are different views to it. Khushi, any views on this?
पार्टनरशिप एग्रीमेंट में और पार्टनरशिप डीड में
क्या डिफरेंस है? परफेक्ट, एग्जैक्टली दिस इज द एग्जांपल आई वाज अबाउट टू गिव.
मुझे भी 10 मिनट लग गए सोचने में.
Agreement to sell deed is very clear different. But say we say partnership agreement, say partnership deed of retirement.
Deed is a concluded document. An agreement is
Agreement can also be a concluded agreement.
concluded agreement, but it is subject to.
No, that is not the difference. The difference is a deed always conveys some right, title, interest in some property, movable or immovable. There is an actual conveyance involved in a deed. In case of an agreement, that agreement does not actually convey something. It is, it could be an agreement for lease, it could be for leave and license or anything like that. But leave and license is not a deed. Leave and license is an agreement because it is not conveying anything. A deed, say in case of a partnership interests are created, so conveyance is taking place, actual. So that's why it's known as a deed. So deed and agreement, that is a difference. So we have to be very careful as to what we are writing in the substance of that. So agreement in simple terms means an offer from one party, acceptance from another party. Agreement precedes the contract. Deed refers to document pertaining to alienation of immovable property in accordance with the legal requirements. So a deed is always a conveyance. In England, deeds are drafted either as deeds poll or indentures. They use these terms in England. We don't use these terms here. All deeds should be described by the name of transaction which they evidence. For example, this deed, gift is a deed because there is an actual conveyance. Mortgage is because you are actually giving it the property. So these are deeds. These are not agreements. When deed is of complex character and evidences different transactions, it should simply be described as this deed. This deed is executed on so and so. जो interpret करना कोड करेगा. Now here again there are issues. There are two types of persons in an agreement: a natural person or an artificial person, or say entities like partnership companies. We should be very careful as to what terms we are using to define them. Let me say in the bracket, and includes heir, successor, assignee. Copy paste में in case of a company heir आ जाता है. Standard. वो copy paste हो गया, change हो गया. अभी company का heir कैसे होएगा? So successor, assignee. Now I've used two terms here just to describe assignee and permitted assignee. Extremely important. Extremely important. Very important. What is the difference between these? Very important. I think I've explained in the office one. इसको मालूम नहीं बताया नहीं. कोई बता सकता है कि हम ये यूज करते हैं कहाँ पे? कहीं पे permitted assign, कहीं पे assign. And as a developer, you must know this because it will really help you in your deals subsequently. Say you are using these terms, assignee and permitted assignee or permitted assignee, for the landowner, to describe the landowner. Now, or to describe yourself as a developer. So what it means is, in case of an assignee means you can assign the development rights freely to anybody. Permitted assignee means landowner's prior permission for assignment. So that one term, permitted words, make a huge difference to the other. If you have used the word assignee and there is no clause restricting your assignment separately in the development agreement, then it is freely assignable. He cannot say कि नहीं आपने मेरे से पूछे बिना assign किया. He cannot, because there is nothing restricting it. But if he just puts permitted assignee means only if he publishes. So that one term in the beginning which normally people copy paste can make such a huge difference. So we are very careful while using this. Secondly, these words don't come in a leave and license agreement. The licensee जिसको आप दे रहे हो उसका कभी ये चीजें नहीं आती. It is specific to the person. Never to heir, executor, never. License is personal in nature. Never write this because the moment you write this, उसकी lifelong property हो जाएगी. Heir, successor आते जाएंगे. So be very careful. Leave and license में ये लिखना नहीं है. DA में permitted word नहीं लिखना है. If you are a landowner, if you are a developer, that is. So these, if you are a developer, don't write the word permitted for the land, for yourself. बाकी ठीक है, administrator, executor, nominee वो रहता है. Obviously, these things are required: name, age, parentage, occupation, residence. In case of a company, resolution details. Resolution details. Some people, I've seen some draft people write. Some they don't write. We feel we should write. The beginning only, authorized by resolution dated so and so. It's very important. And who's the authorized person with his designation? The company, SEIN, PAN, registered office address. Statutory recognition means it's registered under which act? Companies, LLP, Partnership Act. This is important now. Parties should be given a reference name and they should be referred to throughout by the same name. Now, here, this is a very common mistake nowadays, people. Party 2, first part, herein. Oh God, that document becomes so bulky to understand. Party 2, first part, party 2, second part, and it just says 6-7 parties. You're gone. तो बनाने में डॉक्यूमेंट और पढ़ने वाले को समझता ही नहीं आधा बार क्या है क्या नहीं. Party 2 first. So again, who was the first part? Who was the second?
Every time you have to
go back to. Now this is an English system which was used in 1930s and 20s and all. For last 50-70 years they have also stopped doing it, but in India we continue copying them. Now what the international system is, they use the name, straight away name they use. They give it a short name, say Well-Wisher Construction Private, Well-Wisher. It's very easy to read. Well-Wisher will do this, Well-Wisher will do this, or say Neil Fitzy will do this. It's so easy to read. Why give such bulky names, party 2, first part and second part? I don't understand. Why make it difficult for the person to read? अगर fees extra मिलती बात अलग है. तो ऐसा नहीं. Another thing is, with the word vendor, don't use the word vendy.
Sorry, vending.
Vendy. A lot of people use vendor and vendy. It becomes again confusing. No, in reading. Make it very clear. Vendor, purchaser, seller, purchaser. So it's very easily identifiable. Make it simple to read. So these are the 2-3 things which we in practice we have learned, but people can come out with more examples on what to do. It's a constant learning process. Now, recitals, again there are 2 types of recitals. They have very serious legal implications. So recitals have to be very carefully crafted because recitals are the representation by a party on the facts. If those facts go wrong, then that document goes in misrepresentation and it becomes voidable. So recitals are very, very important, that it should be factually absolutely correct with dates, amounts, area of land, this, that, schedule of property, everything should be correct. So narrative recitals mean the facts, the history. This land was acquired on so and so date through this deed, that, all that. So those facts are the narrative recitals. Then the introductory recital is the recital which describes the purpose of entering into that document. What is that transaction? It should be in a very simple English should be mentioned. That the parties intend to enter into a transfer of this conveyance of this said land, जो said land ऊपर described है. So it should explain the motive of the operative part. कि जो conditions आगे आ रही हैं, वो हम क्या कर रहे हैं? If this is vague, if this introductory part is vague, the courts are unable to decide what is this document for. Whether it is for sale, whether it is conditional mortgage, things like that. So you have to be very clearly mentioned why these 2 parties have come together for what purpose. It should be short, simple English without any legalese. Recital, some rules which must be kept in mind. If both recital and covenant of a deed are clear and unambiguous, but they are inconsistent, the covenant will prevail, not the recital. If the recitals are ambiguous and operative part is clear, operative means covenant, the covenant must prevail. If recitals are clear and covenant is ambiguous, then the recitals will govern the construction. A misrecital may operate by way of estoppel. What this means is that if you have given some wrong facts in your recital, then those wrong facts can be used against you for claiming damages and all. You cannot say, oh, by mistake ho gaya. It can be used as an estoppel. Secondly, those recitals can also alter the nature of your document and say you probably a landowner has entered into a kind of development agreement because of wrong recital, say the introductory part, if it comes across as a sale of the land, then he will be estopped from claiming that it was development and not sale. Then he cannot go back on that. So very important as to how you word the recital part of it, both narrative as well as introductory. Then misrecital will not affect the deed if it be sufficiently clear what is intended. So if the narrative part is wrong, but if the introductory part is very clear that this is what we intend doing, then that will operate. Obviously, it can influence the construction. As I said, courts will. Normally, we in some of the documents we always find a clause in covenant which says that the recitals herein above should be read as covenant of this. There is a legal reason for that. Recite, as we earlier understood, that if there is a mismatch between recitals and covenants, then covenants fail. But if you have put that clause saying that recitals will be treated as operative part or as covenant, then those recitals also have to be read as a covenant, not as a recital by the courts while interpreting the document. It is very legal, but so what we do is we try to write that line that these recitals will be treated as a part of covenant, so that it becomes one holistic document instead of two separate things. Purpose and object of contract should be lawful, and that is the main essence of contract. On essence of contract we covered something very interesting. I will discuss that also. उसमें बहुत झगड़ा होता है, but commercial terms should be complete, should be clearly defined. Now these are conditions precedent, conditions subsequent. As I said that in the document we must break the conditions into two parts. If you are a developer, then your obligations, if he has put in a lot of obligations on you, then you must break your conditions into two parts. Which are the conditions precedent? Precedent means before the document becomes effective, and which are the conditions which will be after the documents become effective. And try to push as a developer as many conditions into the conditions subsequent instead of conditions precedent, because the legal implication different है, that I'll just explain. Condition precedent is an event which must occur for enforceability. So if condition precedent doesn't take place, then the document is not enforceable. But condition subsequent is an event that brings an end to something. So if you have fulfilled the subsequent events, then the document, that act is over. So it does not affect the enforceability, it closes it. Condition precedent is a duty, and condition subsequent brings a duty to an end. So once you have fulfilled the subsequent events, your duty has come to an end. Now condition precedent, if you have not fulfilled, then the other party has an option to treat that document as void at his discretion. इस precedent conditions हुई नहीं fulfill, तो document आगे बढ़ाना है नहीं बढ़ाना है वो उसका option हो जाता है. But if condition precedent has been fulfilled and condition subsequent has not been done, then what happens is that agreement cannot be terminated. The remedy is different, but the other party will be bound by it. So what happens? That damages, in case condition precedent is not fulfilled, then he can treat the agreement as void and he can claim damages. But if condition precedent has been fulfilled, but condition subsequent has not been fulfilled, then the other party can only claim specific performance. He cannot cancel the document. He can claim specific performance कि भाई ये डेवलपर को ये काम करना है तो आप specific performance करो कि he fulfills this, and he can claim damages and dress along with it or whatever. But he cannot cancel the document. So this is, and that is where Bombay High Court, as in so many development agreements, said that if you have not started your development activity, then that agreement can be terminated because your condition precedent has not been fulfilled. So it has become terminated. That is very important. So keep in mind that while drafting. Now testatum is.
Sir, on this, just one question.
Sure.
If he now condition precedents are not fulfilled, can the agreement be suo motu cancelled?
Yeah. Yes, he can. He can suo motu terminate.
Even if it's a registered document.
Yes, there is a Bombay High Court judgment in case of a society where the society gave a public notice, and they gave a public notice saying to Chimbur society, they said that 4 साल हो गए थे, कुछ हुआ नहीं था, they had vacated the premises, they were living on rent, but the builder had not started the activity. Demolition करके छोड़ दिया. So they said that this is not being done, so we want to now engage another developer. So they gave a public notice in the newspaper that his power of attorney and his agreement stands terminated from so and so date.
Stands terminated. Registered document.
And so the developer went to the court saying that I have a binding this thing, they cannot terminate it through public notice, it is a registered document now. Bombay High Court said no, nothing. You have failed to perform your duty totally. You are not going to come forward for a registered cancellation deed, so society has no option. This is a valid way of cancelling a DA which is not being effectuated. So they have held. So that's based on basically.
There is general presumption that a document which is a registered document cannot be.
See, these procedural things cannot take over the law.
Yeah.
Law is, it's very logical. You know, if you have not performed.
So the same thing applies to our sale documents also.
In what sense? Can you give an example? Like sale documents for the flat?
Like purchaser sale document, we have executed a registered document. And suppose he was to make some X payments or there were some obligations which were at his end were supposed to be completed.
Yes.
He has not done it.
He has not done it. So that's what I feel.
Then how do you cancel that document? Just by simple notice to him?
See,
in the document there are provisions. You will give him a 15-day notice.
Correct. You have done all that.
You have done all
he has
that.
not come
And
forward.
he has not come forward.
Yes.
Sometimes
Now,
that party is not traceable also.
True.
They don't reply to any of our notices also.
See, the problem there is, sir, that these two documents, the development agreement and agreement for sale for a flat, they are they are governed by two different laws. Development agreement is governed by the contract. It's a contract. It is not sale of property or transfer of immovable property. So different laws apply there. It is easy to terminate that. The transaction for sale of flat is a transaction of sale of immovable property. So there what happens is that you have to go to the court to get the document, registered document cancelled.
You have to go to the
Yes.
court. There is no option.
Now under RERA there is an option. Now under RERA you have to just inform the regulatory authority. Regulatory authority will give him time for 30 days. If they don't make payment in 30 days, they will cancel it.
As of now, what it stands is that you
As
have to
till
go
RERA,
to court.
as of
You cannot suo moto terminate
no,
that
you
document.
can terminate. See, I'll just
Termination. You can't sell that flat to somebody else.
No, you can. But what happens is, you, on the safe side, legally you can, but safety wise what happens is, you can cancel it and then you have to apply to the court to get the instrument cancelled.
Okay.
So one is the termination of agreement, that termination you can do suo moto.
But instrument continuing unless it is cancelled, the search
No.
and everything, it will reflect.
No, but that cancellation of instrument is not a condition precedent for you getting into another
New
agreement.
agreement.
But what happens is, suppose that matter goes into litigation, then this transaction will get affected. So on the safe side, people say that पहले वो cancel करा लेते हैं तब ये sale करते हैं.
बराबर.
But there is no legal requirement. It will not be treated as double sale.
Okay.
It will not be treated as double because you have cancelled it. There are records to that effect, and that cancellation of instrument by court is a procedure. It's just a legal procedure. Okay. But it is not advisable to do that. Advisable is to get it cancelled and then send it. और क्यों झंझट, आजकल बिल्डर वैसे ही सब वो नेगेटिव से चालू होता है
एक हमारा 7 साल पुराना डॉक्यूमेंट है ऐसा,
अरे बाप,
अभी भी चल रहा है. I can't sell the flat to individual. ऐसा
तो you cancel it
कैंसिल तो कर दिए 7 साल पहले.
so you lodge it for cancellation. See, court will give them a summon. They will not attend. If they don't appear, then court after 2-3 summons they will cancel. अब उसके ऊपर वो कैंसिल करके वो एंट्री करते हैं डॉक्यूमेंट के ऊपर एंड देन दे गिव इट टू यू. द कोर्ट राइट्स कैंसिल. सो देन इट बिकम्स now what is the testator is that there's a line between the recital and the covenants that comes from now this deed witnesses as we so generally write that, you know, पता भी नहीं क्या है, पढ़ता भी नहीं कोई, कॉपी पेस्ट करता है. उसका भी बहुत डीप मीनिंग, बहुत इंटरप्रिटेशन है उसका भी. If it is substantially put, then it becomes the whole purpose of the document, and the courts use it for interpreting what the nature of that document is. So that also needs to be very carefully drafted. As a part of strategy, you can keep it vague and say now the parties hereby agree. If you want to keep it vague, but if you want to be very specific, then the ideal way of writing is this. Now therefore, in consideration of mutual covenants and in reliance on the representation and warranties contained in it, and for good and valuable consideration, the receipt which is hereby acknowledged, the parties hereto intending to be legally bound hereby agrees as follows. Now, this, if you use it in an MOU, what will be the effect?
Completely binding.
Completely binding.
No
Now
one
what you
reads
do?
this.
Nobody reads this.
Wait.
You may write anything in the MOU, not binding, ye, wo, sab, but you write this in the court will interpret this. You're legally bound. You take the payment, receipt लगा है, mutually agree किया है, so और क्या चाहिए? Contract क्या होता है? So these are the tricks or the plays are available to you on in various ways. Normally what will happen is the moment we write such a big test data, वो सामने वाला लॉयर खड़ा हो जाएगा, ये क्या है, ये क्यों लिखा है? तो 3 वर्ड में होता है, ये क्यों लिखा है ऐसा? So that is also a problem. But if this goes through, you have a binding MOU. So, and these are very freely used in commercial contracts. Covenants known as operative clause. So these are the promises that I will do this, you will do that. All those terms, conditions. These are covenants. What will be done, what shall not be done. So these are of 2 types. These are negative covenants and affirmative. Negative is what not do. Affirmative is what you are supposed to do. Now, इसका legal implication है. बहुत serious. When you put in a negative covenant, and if the matter goes in dispute, then the court will easily grant you a stay, saying, हाँ इसमें लिखा है ये नहीं करना है, तो अभी stay करो, अभी आप ये नहीं करना जब तक matter settled नहीं होगा. So if you put in a negative covenant for the opposite party, which I have covered subsequently in case of a land or a development agreement, you will put this on the landowner that this will be a mutually exclusive document and you will not deal with anybody else till this document is in operation. अगर वो डाल दिया, then you can easily within first hearing you can obtain a stay from the court because they'll say okay ये dispute settle होना है but आप वो covenant follow करो, you will not deal with the other party, so you block it. So negative covenant are easily to you can obtain a stay on this. But if there is a positive this thing कि ये करना है, उसका डिग्री बहुत आसानी से नहीं मिलता कोर्ट से. वो कोर्ट आपको कुछ करने को नहीं कहेगा, कुछ ना करने को इजीली कहेगा. हाँ. So how we word the covenant उस पे बहुत आ जाता है. Positive covenant can be worded negatively so as to keep in mind कि future में वो अपने को stay लेना है उसमें. अगर लेना है, लेना पड़ सकता है तो then we word it that way. So those covenants are important. Then covenants can be divided into what is the subject matter, what are the encumbrances, charges on the properties, and peaceful possession, कब possession देंगे and all that. Further assurances, हम ये करेंगे, आप वो करोगे. These are the kind. Subject matter, it runs with the title of land enforceable against seller and all his legal representatives. But the other 3, that is encumbrance, covenant for peaceful possession and assurance, are only personal covenants against the seller only, not his legal heirs. Legal heirs के लिए अगर आपको उनको भी liable करना है इनके लिए तो उनको पार्टी बनाना पड़ेगा, which we normally insist on. Farmer है तो उसका सब family सब कोई sign करवाते हैं. नहीं भी required नहीं तो कल को आके बोलेंगे हमारा right दे दिया ये करते हो. Then representations, again this is also very I'll go a little fast on this. This is highly technical. Representation means when each party represents, like we represent, we are a builder of repute and this and that, and all those things we say in a document. So we have entered into a landowner says कि the land is free from encumbrance, there is no charge in absolute possession. चाहे उसकी उधर 10 वो unauthorized construction होंगे तो भी वो लिखता है absolute possession. Very normal. वो mistakes जाती हैं document में. वो sign भी करता है वहाँ absolute possession and all that. So those are all misstatements. I'm not talking about the repute of builder. I was talking about the earlier part, the subsequent part. So वो सब क्या है कि those are all misrepresentations, and based on that misrepresentations you have a remedy in the court. That is, one is that you can treat the document as voidable, saying that okay I don't want to go ahead with this, there's a mistake, or you can claim damages, or you can go ahead with the document by ignoring that and getting it corrected. So all those options are open. So representations very carefully to be drafted so that there is no misrepresentation in it, otherwise it can cancel the document totally. Warranties are that what you will do, that's little futuristic, and you say that okay I gave a guarantee कि मैं इतने दिन में कर दूंगा, ये construction कर दूंगा, ये कर दूंगा, वो कर दूंगा, minimum sale price इतना होगा. Those are the kind of warranties which you give. So now what is the difference between a representation and warranty? That in case of false representation, contract becomes voidable. But in case of a warranty, the contract is not voidable because it is futuristic that you will do that. तो contract तो हो गया, but अगर उसका breach हो गया, say you promised that okay मैं 4 साल में possession दे दूंगा बना के, 4 साल नहीं हो पाए, so उस breach का क्या है, आपको या तो damages मिलेगा या suppose कुछ किसी का specific performance claim कर सकते तो वो specific performance claim करेगा, but he cannot cancel the job. So how you word your representations and warranty is very careful. The warranty should not form part of representation, otherwise he gets excess power. Try and shift representations to warranty so that document cancel नहीं करता. Then indemnity, this is everybody knows that I will make good your losses if it happens. They are different from damages. Now this damages part I will discuss because इस पे बहुत डील्स टूटती हैं. Understand the logic, legal of it. You can write anything you want in damages clause, it will not be affected. No courts will enforce it. Courts go by section 73 to 75 of Indian Contract Act. Damages can never be penal in nature. First law. If you write that landowner, if there is litigation on land and I have to cancel my development agreement, I will take full potential of my project profit from him as damages. Court will throw you out. Court will say loss you have to prove. Only the loss which can be proved can be allowed as damages. Nothing more than that. You can write what you want, it is not enforceable. So don't negotiate on damages clause so much and break the deal. You can write 100 things, landowner will write, if you don't give me possession by such period, you will be liable to pay so many rupees per month plus this plus that. Lick them. When you go to enforce it, the court will ask first prove your loss. Do you have another house to stay in? Yes. What is your loss? So damages are only allowed as per law, nothing as per contract. Whichever is less.
Irrespective of whatever quantum is written in the document.
You have to prove your loss, not more than that. Actual loss only can be allowed as damages.
वो notional कोई भी figure डाल दे, we should not bother.
Should not bother. वो इसमें कितना लिटरेचर है, मतलब कितना जजमेंट और कितना कुछ है, बट डील्स टूट जाती है इसके ऊपर. Now indemnity, I just explained. Indemnity is an undertaking by one person that if this thing happens, then I will cover your losses. Damages are directly between the parties. Third party is not involved. So here in indemnity, third party losses are covered. I mean, this is a little technical. So actually, I just skipped this slide because it's not very important. Damages part was important. Indemnity is real estate में हम लोग कोई देता नहीं है तो इसके लिए इतना important नहीं है. Now these are boilerplate clauses. These are clauses which exist in every agreement. It is like that तवा सब्जी जो अपने को शादियों में मिलती है ना, वो सब सब्जी होती है, वो मिक्स करते हैं. It's like that. So that's why it's known as legally it is known as boilerplate clauses. इसमें सब तरह के clause होते हैं. And these are normally copied and pasted. ये 20-25 clauses होते हैं. Copy paste कर दिया, last में document इतना बड़ा लगता है वो 10 पेज का. But इन clauses का बहुत deep meaning है. And if they are not rightly worded, it can create chaos. So relationship between parties means how does the parties define themselves? Like we write that it's a principal to principal basis. It's not an agency between developer and this thing. These are implications, especially under RERA. That if you say principal to principal basis and all those things, then probably landowner will be escaped from the liability of RERA and only the liability will be on it. And this is also true from the जो draft अभी आया union territories का RERA. Then notice. How the notice will be sent to the other party at what address? Very important because इसमें बहुत litigation है. You have to send the notice at the last known address by RPAD or by speed post. अब email भी लिखने लगे हैं लोग बोलते email मिला नहीं, but section 89A में वो Indian Evidence Act में it's covered. Now courts recognize all emails and everything. So as to our builder clients we say don't write the email. अब पागल हो जाओगे, इतने email आते हैं. कोई भी बैठा है आज घर पे संडे को, चलो यार बिल्डर को एक मेल भेज दो. बिल्डर पे एक स्टाफ बैठाया हुआ है, वो बेचारा ईमेल का ही रोज जवाब देता जा रहा है. सो अवॉइड ईमेल एज फार एज पॉसिबल. असाइनमेंट आई जस्ट कवर्ड इन 2-3 ways. permitted assign not, so उस तरीके से assignment. Waiver, whether if you have not taken action on a delay, whether it tantamounts to waiver of your right or not. Saving of rights. खुशी?
वही agreement terminate हो गया
तो क्या rights बचते हैं?
damages are
हाँ, but suppose if the document is treated as null and void because of some reason, कुछ वो हो गया कि ये misrepresentation से तो ये cancel हो गया. तो cancel हो गया तो सब खत्म हो जाता है या there are certain rights which remain, right to claim damages, right to claim interest or whatever. तो वो पार्ट के लिए saving of rights का clause आता है that even on cancellation or termination due to any reason, these rights will still remain. So that is to be carefully drafted. That is very careful.
ये बहुत important है,
बहुत
सबसे ignored है.
सबसे ignored है और सबसे ज्यादा important. Survival, that in case of cancellation of the document or termination, which clauses will still survive? It's different from saving of rights. Right was which rights will remain with the parties. This is which clauses will still survive. Like arbitration clause will survive. Claim of damages or interest, those clauses will survive even on cancellation of document. So those have to be mentioned in the document. Severability, that if a part of the transaction is treated as illegal or invalid due to some reason, whether the other part which is valid can still be enforced. So in severability we normally write that if some part is treated as this thing, the part which can be separated and enforced will be valid. So part of the document will still be valid. Invalidity clause, that invalidity will not take away certain rights, it's closely related to saving of rights. Governing law and jurisdiction, which law we will govern by, which court we will be governed by. Dispute resolution, that is arbitration, sole arbitrator or 3 arbitrators. Why go for 3 when you can go by sole? Then if arbitrator is not appointed within 30 days by parties, then let the court decide. So it speeds up the process. So this dispute resolution, arbitration clause should be very, very clearly defined, very properly, meticulously done, because it can save a lot of cost, money, time, everything. Costs and expenses, who will share the costs and expenses, stamp duty, registration fees and all that, those clauses. Consent of specific performance. Now this is a clause which landowners are not happy to do. We insist on this, that we always write a clause saying that this document is specifically enforceable under the law. Now landowners are not very willing to do it, because the moment you write that this is specifically enforceable document, specific performance, then वो अटक जाता है, उसका लैंड अटक जाता है. You can always get a stay on this basis that he cannot deal with somebody else. So counterparts means how many copies of that. Reference क्या था? हाँ, reference to other laws and this thing. Title, the title of the paragraphs will not be important. Confidentiality, if confidentiality is required. In case of real estate transactions, no document is confidential, because the moment you register it or you give it to banks and all, it becomes a public document. So that confidentiality clause does not come in immovable property transactions. Exclusivity very important.
जब तक रजिस्टर नहीं हुआ है कोई कॉन्ट्रैक्ट इमूवेबल प्रॉपर्टी का, तब तक कॉन्फिडेंशियली क्लॉज और एक्सक्लूसिविटी
नहीं. Then see, the moment you put confidentiality, then the problem with developer is he cannot market that MOU and get partner.
हाँ, वो उसी का सर आंसर आता है जब एक्सक्लूसिविटी की बात करते हैं.
एडवांस भी
नहीं, एक्सक्लूसिविटी लैंडओनर के पॉइंट ऑफ व्यू से लगता है.
एडवांस भी नहीं ले सकता है.
हाँ, प्रॉब्लम आ जाएगा. तो कॉन्फिडेंशियलिटी नहीं होना चाहिए, एक्सक्लूसिविटी होना चाहिए फ्रॉम द लैंड ओनर्स पॉइंट ऑफ व्यू, दैट ही विल नॉट डील विद एनीबडी एल्स till this MOU is in. Then any amendment will be in writing and those kind of things. No agency is created. MAT means, I just explained earlier, material adverse change. If there is anything, then this thing will happen if the rate changes or if the price changes. And ये इधर बहुत गड़बड़ होती है. This is a clause, overriding effect. We normally write that this document is full and final. It overrides all earlier correspondences, that and all that, right? अभी वो डील में साइड लेटर बनाया होगा, कुछ और चीज किया होगा, वो सब ओवरराइड हो जाता है. बट दिस कॉपी पेस्ट में चला जाता है. एंड देन यू रियलाइज यार वो साइड लेटर बनाया था तो ओवरराइड हो गया. उसमें है ना, एक बार हमने डिटेक्ट किया, यार ये कैसे जा रहा है, किसने रेरा में वो किसने वो स्कीम था 2 ईयर स्कीम में कुछ किया था, अलग से बैंक को दिया हुआ था कुछ अंडरटेकिंग, और जो रेरा का जो मुफा का सेल डीड बनाया हुआ था क्लाइंट ने, उसमें ये क्लॉज आ रहा था, इट ओवरराइड्स ऑल अर्लियर डॉक्यूमेंट, ऑल अदर डॉक्यूमेंट्स. अर्लियर भी नहीं था,
नहीं, ऑल अर्लियर एंड अदर अंडरस्टैंडिंग्स एक्जीक्यूटेड बिटवीन द पार्टीज.
यार जो बैंक को दिया नहीं ओवरराइड हो गया, ऐसा हो गया. Fortunately, nobody goes to that level to think but अगर litigation आया तो सब खुलता है. So you can't just copy and paste these things. Be very careful.
एक में ऐसे ही था कि रिजर्वेशन लेटर में अलॉटमेंट लेटर में लिखा था कि पार्किंग जो है सोसाइटी अलॉट करेगी, लेकिन जब एग्रीमेंट फॉर सेल किया उसमें नहीं लिखा कि पार्किंग, तो
और वो ओवरराइट कर दिया. रिजर्वेशन लेटर को करेक्ट है. But sometimes we deliberately make this mistake. We deliberately make this mistake. Because लैंड ओनर को एश्योरेंस देने के लिए साइड लेटर या एक एमओयू किया हुआ है, अभी हमने रिसेंटली किया है, तो इसलिए मेरे को याद आया कि हाँ ठीक है यार, ले नोटराइज्ड साइड लेटर ले, खुश है, फिर इसमें लिख दिया हाँ ओवरराइट, तो करते हैं थोड़ा बहुत बदमाशी. ये रिकॉर्ड अच्छा. Further assurance is that we agree to cooperate with each other to give effect any other document required, we will do it. Force major obviously, then cumulative, that all remedies will be cumulative, criminal ये वो सब चीजें साथ चलें. Here we must discuss this because इसमें सुप्रीम कोर्ट का एक जजमेंट है, ये इसमें काफी प्रॉब्लम आया था इसमें अभी जब सिडको वो सर्वे नंबर्स चेंज कर देता है एंड ऑल दोस काइंड ऑफ थिंग्स. शायद अपने एक मैटर में ऐसा कुछ हुआ था, ऐसा पुराना ओल्डे का ऐसा
इनके पुराने सर्वे नंबर अलग रहते हैं, नए सर्वे नंबर आते रहते.
करेक्ट. तो
रेवेन्यू रिकॉर्ड में ऑलवेज होता रहता है.
करेक्ट. तो ये इसलिए ये चीज अफेक्ट करती है. तो सुप्रीम कोर्ट एंड अभी रिसेंटली गुजरात हाई कोर्ट के जजमेंट में उन्होंने कहा कि यू शुड क्लियरली मेंशन द डिटेल्स ऑफ द लैंड इन स्क्वायर मीटर्स, सर्वे नंबर्स, अगर उस पर बिल्डिंग स्ट्रक्चर है तो उसका म्यूनिसिपल नंबर एंड व्हाटएवर द वे इट इज आइडेंटिफाइड. बाउंड्रीज वेरी इंपॉर्टेंट.
नॉर्थ में है, साउथ में है.
यस, वेरी इंपॉर्टेंट. मतलब
सर उसमें 30 to 40% डॉक्यूमेंट्स में बाउंड्रीज में गलत, नॉर्थ में कुछ होता है वो और ही कुछ लिखा रहता है. अरे इसमें मेरा एक क्वेरी है. अगर एक डॉक्यूमेंट अपन परचेज करते हैं, उसका जो डॉक्यूमेंट में बाउंड्रीज में नॉर्थ साउथ ईस्ट वेस्ट लिखा है वो गलत है,
आगे कवर किया है आपका.
What you should write, जो पुराना गलत है वो लिखना कि नया लिखना.
मैं वही बता रहा हूँ. मुझे मालूम था आप ये क्वेश्चन पूछेंगे, हमने स्लाइड बनाया हुआ. दिस इज समथिंग व्हिच इज लॉन्ग डिबेटेड इन आवर ऑफिस. अभिषेक लेके आता था, सर ये देखो ये पुराना, अभी मैं कैसे बनाऊं ये होगा. When we did a lot of research, we found certain judgments and we found a Supreme Court judgment, which has given a very clear answer of that. Generally, tendency is to copy paste schedule from previous documents, but it is necessary to verify the correctness and correct it in the subsequent document. You cannot carry on with the error. You cannot. ये बहुत important. Supreme Court has said you cannot. उसमें गलती की तो आपका चला यार, ऐसा नहीं होता.
Should it be mentioned that in the prior document the same property is described as this, but another correct?
Yes. That is required.
No, I don't
maintain the continuity.
Why highlight that? Why highlight that?
Why highlight? पर सर वो नहीं करेंगे तो ये नया शेड्यूल कहाँ से आ गया?
नहीं मतलब ठीक है ना, अब जो है वो करेक्ट है ना, वो तो आप चेक कर सकते हो.
मतलब वो चेक करने जाएगा, but if there is a statement, nothing wrong.
ठीक है, I mean it's basic comfort. मतलब लिख नहीं सकते नहीं भी. मैं I would prefer not to write it just because I don't want to highlight that issue. जिसकी नजर नहीं पड़ रही है फिर नजर पड़ेगी, ऐसा हो जाएगा है ना. बिकॉज शेड्यूल प्रोडक्ट कौन देखता है, नॉर्थ ईस्ट वेस्ट साउथ, क्या ठीक है ऊपर का देखा हाँ ठीक है. देन दिस वी रिसेंटली रेड इन इंग्लिश लॉ की बुक में हमने पढ़ा कि दे से दैट अटैच द मैप इफ पॉसिबल. इट इज वेरी important because if you attach the map of the property besides the schedule and everything, it makes the things very clear exactly what you are buying. This is optional but sometimes necessary to avoid mistakes about its identity, and plan or map should be appended to the deed, and the words for greater clarity or by way of further identification are added to indicate that the description controls the plan. This is very normal. At the end of the document, we write witness whereof the vendor has put his signature and all that. Every document is required to execute it. Now here we know sometimes we write signed and delivered, sometimes we write signed, sealed and delivered. What is the difference? Yes, very important. हमने देखा इंडिविजुअल साइन करता है तो साइन सील डिलीवर्ड लिखा हुआ है, इंडिविजुअल का सील नहीं होता है. सो You have to be careful while writing this.
Okay.
Then this is attestation, that is the witness, and actually witnesses are not required in any of the documents under the Indian law except three. Except only 3 documents require a witness under law. That is a gift, a will, and a mortgage. Besides these 3 deeds, no other document requires a witness legally.
ये रजिस्ट्रेशन ऑफिस में दो विटनेस ले आओ, कोई डॉक्यूमेंट रजिस्टर करेंगे,
कस्टम
और वो दोनों विटनेस आज के दिन में और कोई डॉक्यूमेंट नहीं किया होना चाहिए, उसका प्रूफ.
अच्छा,
व्हाट नॉनसेंस.
ये क्या है, मैं वही बोल रहा हूँ. See, there is a law and then there is a custom. So these are custom based practices. See, law is
सर्कुलर्स टू दैट इफेक्ट कि 2 विटनेस नहीं होगा तो डॉक्यूमेंट रजिस्टर नहीं करेंगे.
लीगली सिर्फ 3 ही डॉक्यूमेंट को लगता है, बाकी को नहीं लगता. बट ठीक है, यहाँ पे एंड सी नोबडी फील्स कंफर्टेबल इन एब्सेंस ऑफ नहीं यार विटनेस दे दो, कर दो, डॉक्यूमेंट हो रहा है, तो इसलिए सब करते हैं. बट लीगली इट्स नॉट रिक्वायर्ड. Then these thumb impressions, males में left hand, females में right hand, but we prefer that जहाँ पे भी प्रॉपर्टी के कुछ भी ट्रांजेक्शन्स कुछ हो रहे हैं, तो चाहे वो लिटरेट भी है, तो हम उसका इंसिस्ट करते हैं कि सिग्नेचर के बाजू में अपना थंब इंप्रेशन भी डालो, स्पेशली जहाँ पे आप गाँव वालों से डील कर रहे हैं, बिकॉज दे आर हैबिट ऑफ टर्निंग बैक एंड सेइंग ये मेरा साइन नहीं है. तो इसके लिए वी इंसिस्ट.
अब तो मैंडेटरी हो गया.
मैंडेटरी हो गया. अच्छा, रजिस्ट्रेशन के लिए मैंडेटरी.
रजिस्ट्रेशन के लिए जरूरी है.
एंडोर्समेंट मीन्स सप्लीमेंट्री, मतलब आपका डॉक्यूमेंट हो गया और अब आप आगे उसमें कुछ बाद में कुछ और चेंजेस कर रहे हैं, तो देन दैट इज नोन एज एंडोर्समेंट. और वो भी ऐसी बनता है जैसे डीड बनती है. एंड उसमें लेकिन पूरा रिसाइकल नहीं आता कि पूरा बनाना है ऑल दैट. जस्ट राइट कि ये सब चीजें हैं. भी से ओरिजिनल डीड जो होती है उसको विद इन रिटर्न डीड वर्डिंग्स करके लिख दो, विद इन नेम पार्टीज, विद इन नेम. तो वो this is a practice not followed in India, but this endorsement is that on the same document आगे वो endorsement हो जाता है for changes on the same document. In India we have a different system of called a supplementary deed. Endorsement is also a system which can be followed, but since here the documents are registered and also it is not proper to endorse on those, so we make a separate supplementary deed and we register it. तो इसमें supplemental में we should clearly mention that it is a supplementary deed to the earlier deed which is known as a principal deed. So we should define what the principal deed is. Recital should be very short because recital already उधर आ रहा है, so we should just say as per the principal deed. And this time essence of contract, this is a line we have seen in almost every document. Now whether by writing this line time is essence of contract, is time as an essence of contract? Absolutely no. Time is never an essence of contract. You may write what you want. The moment you write that in case of delay, further extension and interest and this and that, time ceases to be essence. One straight line, and in every document we will find extension होएगा तो इतना interest and all that. So as a developer, you should not worry if the landowner insists that time is essence. आप लिखो 4 साल में बना के दो, नहीं हुआ तो हाँ तो आप लिखो मेरे को आप इतना ब्याज दोगे, ये दोगे, लिख, ठीक, खत्म हो गया. टाइम इज एसेंस. टाइम इज एसेंस ओनली इफ इट इज actually an essence. If you keep giving him permission, extension and all that, interest, तो खत्म, there is essence. So that's what Supreme Court has said. It is stated that mere mention of specific date for completion of contract or fixing the penalty for default does not establish intention of the parties. Such intention may be gathered by language, nature of property, and conduct of parties surrounding at or before the contract. When contract itself provided for the clause for extension of time, as also in view of the nature of contract, time can never be said to be the essence. So, इस clause से कभी डरना ही नहीं है किसी को, मतलब कोई फर्क नहीं पड़ता. Section 55 of Indian Contract Act, contract becomes voidable after the lapse of specific time. That is the effect of time is essence. That अगर वो एक्टिविटी उतने पीरियड में नहीं हुआ तो इट इज वॉइडेबल एट द ऑप्शन ऑफ अदर पार्टी दैट यू फेल्ड इन योर परफॉर्मेंस। बट वो अपना इसमें लगता ही नहीं डेवलपमेंट एग्रीमेंट। कितना प्रॉपर्टी बिक गया होता है, थर्ड पार्टी राइट्स क्रिएट हो गए होते हैं, कैसे कैंसिल होएगा? इट कैन नॉट बी डन। These are various judgments. And when will it be actually considered as essence? Where the parties have expressly agreed, where the delay operates as an injury, मतलब delay की वजह से उसको बहुत major कोई loss हो रहा है, and where the nature and necessity of contract required it to be so constituted. Immovable property के transaction में नहीं. Courts have said that immovable में essence time is never in essence of contract. The date of completion of work should be specifically mentioned in the condition precedent and not a mere warranty. Even if stipulated time was extended further by mutual consent. तो वो condition precedent में जाना चाहिए. वो condition precedent में कभी भी नहीं जाता, वो warranties में ही जाता है कि I undertake to complete in 4 years. So when we were discussing that, try to shift everything in warranty, or it should not form part of condition precedent. This is one example. The time is not necessary. In drafting, it is not enough to gain a degree of precision which a person reading in bad faith cannot misunderstand. In simple English, it means that while drafting, we have to be so precise so as to ensure that if a person who is reading it with utmost bad faith, trying to take out some points to hurt you, he is not able to do so. So that kind of precision is required. Deed should contain all material facts, norms, conditions. Intention should be clear by plain, simple English. Use active, not passive voice. Understand whole design before you begin drafting. This we always internal है हमारा, but we say कि let's make the structure of our draft, then we fill in the clauses. But first, let us understand how we will go about doing it. Then this is a common mistake. Will, shall, must, and may are very wrongly used in the drafts. Will, shall, and must are command. You will do this, you shall do this, you must do this. And may is a permission. You may enter the land, you may do this. So interchange नहीं हो सकते words. Interchange के तो उसका meaning change हो जाता है. Be clear, direct, precise, not reflective or provocative. Natural meaning के words. Recital should be kept at minimum. Real estate इतना possible नहीं हो पाता है, but try to be minimum. हाँ, this is important. Law on the subject should be carefully known. Like I just explained, what checks are subject to realization. अभी वो law पढ़ा तो समझा वो line का meaning क्या है जिसके ऊपर. So unless we know the law, we will not be able to really negotiate or get the deals done. Verification of signature should be done.
What does it mean, sir? Verification of signature?
I mean, ये थोड़ा odd है. Textbooks say that, but they say that the person who's signing it, how do you know that the signature he has put is the real signature of his? है ना? We have had clients जो
Insist on confirmation from banks.
नहीं, जो खुद ही वो पठान साइन करते हैं.
Yeah, then.
So that's when the thumb impression comes in handy.
Huh?
Thumb impression comes in handy.
हाँ, thumb impression नहीं. See, registered document are all okay, but say if you are entering into an MOU or things like that, it's notarized.
तो भी thumb impression अभी आ गया उधर.
अच्छा.
नहीं लगेगा.
नहीं, legally तो नहीं है.
प्रैक्टिस ही हो गई है अभी.
प्रैक्टिस हो गई, कस्टम. हाँ, अभी लेना बेटर है.
पर जो सिग्नेचर कर रहा है उसका कोई आईडी भी तो होता ही है ना, लाइक पैन और समथिंग, तो उस पे भी साइन होता ही है. सो आपने आईडी लगा दिया.
कौन लोग क्रॉस चेक करता है? कोई नहीं करता.
कोई नहीं करता और ना ही कर पाते.
हाँ, कह भी नहीं सकते.
नहीं, अपन ने अपने एक केस में देखा है क्या कि एक्चुअली अपने सामने उस आदमी ने सिग्नेचर किया है, स्टिल कोर्ट में एफिडेविट किया कि ये मेरा सिग्नेचर है नहीं.
तभी तो मैंने बोला ना उस समय की
That is
12.5% में तो बहुत होता है.
ensure.
हाँ,
How do you verify?
how do you verify? I mean, you have to take some signature, some official signature जहाँ उसने किया कि भाई देखा आपका तेरा सिग्नेचर यही है.
एडवोकेट ने एफिडेविट दिया है, इसने मेरे सामने सिग्नेचर किया है, उसके बावजूद उस आदमी ने कोर्ट में एफिडेविट दे दिया कि मेरा सिग्नेचर नहीं है और कोर्ट ने कोई कुछ नहीं किया.
थंब इंप्रेशन लो
थंब भी लोगे तो भी एक्सपर्ट के पास भेजना वगैरह.
फिर भी
कुछ तो है.
वीडियोग्राफी भी करते हैं अब तो, साइनिंग एंड ऑल दैट. तो बहुत
वो
सारे.
अच्छा है, वो अच्छा सिस्टम है.
Videography.
हाँ.
Then again, this last point is again very important. See, there are at times overwriting in the document. कहीं कोई blank है हाथ से fill किया and all that. That has to be at that place. Every party must sign full signature, not initials. A lot of people say initial document. No, full signature is required because that is treated as an alteration in our document, legal document, mandate. So unless your full signature is there, that it will not be effective. That particular clause will not be effective. You can always say that it is not done. So we take उसका यूज भी हम लोग कर लेते हैं कई बार इसमें. हाँ, full signature endorsing the correction should be done. This is the point. Wherever area is mentioned, care should be taken that it is correct. To be on the safe side, it is advisable that after the area, but approximately or more or less should be added. So that अगर वो बोले नहीं 2 square feet कम है 150, at least you say कि it's not specific, it's approximate. That's it. I'm trying now. Any other questions on this or any other suggestion, any examples? Bansali sir, you would like to give? आपके बहुत सारे examples हैं contract drafting के. Thank you so much for attending.